My Lords, I have a very brief point of clarification that arises out of a submission I made before lunch, if I may.
Yes. Just give me a chance to give you my full attention. Not everybody wants my full attention, but if you were to want it, hang on a second. Right.
My Lords, there was an exchange with the bench about the possibility of seeking disclosure of a statement of objections, and the submissions I made concerned the period relevant to this claim and also were correct in relation to the position for the Vodafone claim before Mr. Justice Birss. But it's been drawn to my attention that since then the position has changed in 2015, and so Article 16, Article 16A, subparagraph 3, subparagraph A of Regulation 773 of 2004, as amended by Regulation 2015-1348, provides that information that the Commission has drawn up and sent to the parties in the course of its proceedings shall not be used in proceedings before national courts either by adopting a decision, until the proceedings are terminated, either by adopting a decision or has otherwise terminated the proceedings. So I understand, I'm told that the Commission takes the view that that does preclude the disclosure of a statement of objections. It's a proceeding which came into effect on the 3rd of August 2015, and so it doesn't actually apply in the relevant period for this claim when there was an SO but not a decision. And it doesn't apply once proceedings are closed, whether they're closed by means of a decision or closed in some other way. And of course query what status that has post-Brexit. But
well, it doesn't have any effect on this case.
My Lord, it may well be. I simply didn't want to leave the impression.
No. We'll have to have that in mind.
And there's no equivalent, I think, in relation to the court and Ofcom or CMA or other regulatory proceedings, so far as I'm aware.
Not that I am presently aware, and it might assist if we simply send the relevant provision to.
If you could, just so insofar as we need it, we've got chapter and verse. That would be helpful. Thank you very much.
Yes, Mr. Turner.
Well, sorry, there's just one thing to chase up on that too, as it's jogged my memory. The Damages Directive 2014 was implemented into our law. I think also has a provision which says that where there's an ongoing Commission investigation, statements prepared for the purpose of the investigation shouldn't be used in national damages proceedings.
Should not.
Shouldn't be. Yeah, should not be. And my recollection is that that has passed through into the implementing legislation, which I need to check whether Brexit has affected the consequences, or indeed, your Lordship's point, whether in national law that extends to other bodies beyond the Commission too.
That was the real reason that Mr. Justice Bacon granted permission, because of the potential implications, I think, for future actions.
She did.
She had that in mind, at least, I think.
My Lord, that's right, and that's a good cue for my reply, because this is an extremely important case in this sphere. The decision of this court will have a very major effect in the way that litigation is conducted in this area, as I'll seek to explain in the course of the reply. It is something that does deserve very careful attention for that reason, and I'll seek to give it. The critical issue, as my Lord Master of the Rolls identified in ground one of this appeal, is the test for when a claimant discovers, to use the language of section 32, that there has been deliberate concealment from him or her of facts relevant to the right of action. And that is the first point on which I will reply. Mr. Jowell's position yesterday was that one answers it by asking oneself simply whether a pleading of the underlying cartel damages claim would survive a strikeout. If it can survive a strikeout, you can plead it. If you can plead it, the protection in section 32 is gone. Now,
I don't remember him saying that as the test. In fact, I remember him saying something different, admittedly under a bit of pressure from me. But I remember him saying that he agreed with you.
Well, without attributing it to him then, let me deal with that proposition in the abstract.
Okay.
Whether, if you have a pleading that can survive a strikeout, and you're in a position to put one on paper, that is sufficient to mean that the protection in Section 32 of the Limitation Act is lifted.
But isn't that obvious?
I would say no.
Okay.
I would say no, and that's what I want to go through.
Okay.
Because leave authority to one side for the moment. The central problem of policy, of principle with the proposition is that it is a gossamer thin test. It means that as soon as a claimant has got a basis for pleading something that's not in the realm of being purely speculative or unrealistic, and you're looking forwards to what will be available at a future trial, time starts to run because the pleading won't be struck out. Now that is an extremely low bar for discovery of the relevant facts, and in my submission it is not correct. It's not correct because, taking it in stages, it doesn't mesh with the wording of the statutory provision, which refers to the claimant discovering that there has been deliberate concealment by the defendants of the facts relevant to the cause of action. And nor does that test fit either with the FII embarking on preliminaries test or the statement of claim test properly understood. And before I turn to address embarking on preliminaries and what it really means, I do need to make one significant threshold observation. The judge below proceeded on the basis that the statement of claim test applied and that all the parties to this appeal, we came to this court on that basis too. FII doesn't actually ditch the statement of claim test. It continues, as your lordships have seen, to envisage it applying in the instance of fraud. That's paragraph 191 of the judgment, where the court says this isn't the occasion to revisit that.
Well, it doesn't say it continues to apply. It says we're deciding mistake.
My lord, you're right, and perhaps I should avoid being telegraphic. If we turn to that, it's Authorities 25. If we open FII, in the opus numbering, page 88. So what they say is the formulation adopted in Halford and Brooks and Hayward and Fawcett's and AB in the Ministry of Defence places the commencement of the limitation period slightly earlier, words I mentioned at the outset yesterday, than the fraud cases discussed earlier. The relevant time is when the claimant knows with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, rather than the point in time when they could plead a statement of claim. This is not the occasion on which to review the formulation used in the fraud cases, which reflects the special standards applicable to the pleading of fraud. Now, we haven't troubled this court with certain first instance judgments that were given after FII, which did consider where deliberate concealment does sit. There was one by His Honour Judge Pelling, which we haven't included in the bundles for this court. But the point is that FII did not take a view on whether deliberate concealment is in the fraud camp or in the mistake camp. And we say the following, that in principle, deliberate concealment falls on the fraud side of the line. And I make two observations. First, mistake, unlike deliberate concealment and fraud, is concerned with the appreciation or the perspective of the the victim or the claimant. Deliberate concealment and fraud both refer to elements of conduct by the other party, by the defendant. And secondly, the two are closely related in terms of the concern, the policy concern, which you can broadly refer to in the category of unconscionable conduct. And it is those common dimensions that were recognised in one of the Court of Appeal cases which followed FII, namely OTC Computers, the judgment of March last year, and the judgment specifically of Lord Justice Males that I took you to yesterday. If I may invite you to briefly look at that again. It's Authorities tab 27. And if you go in it to page 21, you have paragraph 60. I referred to this paragraph in a slightly different context yesterday, but you'll see here that the judge is dealing with the proposition that one should treat a claimant in administration or liquidation as if it was still carrying on the business when one is applying the Section 32 test. And the reasoning of the judge, about 5 lines down, is it's moreover unnecessary to be too sympathetic to defendants who have committed fraud, 32.1a, or who have deliberately concealed wrongdoing, 32.1b, and who, if they wish to ensure the limitation period begins to run, can always make a clean breast of it by contacting their victims. And then, just to remind you, if you go back to paragraph 18 on page 10 of his judgment, that is where he clarifies that the sort of case we're dealing with here, unlawful secret cartel behaviour, inherently is an aspect of deliberate concealment.
I mean, if you're going to make this argument, Mr. Turner, which you did not make yesterday, or in your skeleton,
well,
it seems to me that you're going to have to show, at least me, why the 9 reasons given by the Supreme Court for fixing an earlier date for the start of the limitation period don't apply here, whereas they do apply in mistake.
Yes, my lord, as to that, I am sorry that this wasn't trailed in writing. We did come to court on the basis that there was common agreement that the statement of...
Yes, but it should have been obvious to, if I may say so, extremely experienced advocates on all sides, that the Court of Appeal is not in the business of deciding cases on the agreement between the parties which falsify the law.
My lord, the point is well taken. In relation to the observation you've just made, my only submission is that for the reasons that I've given, fraud and unconscionable conduct, the expression of which is deliberate concealment of the wrongdoing in this sort of case.
Well, I mean, I understand that, but the reasons that they give, that the purpose of the limitation period, the whole objective, is not to put claimants in a better position because they've been the subject of fraud or deliberate concealment, to put them back in the same position they would have been in if there hadn't been fraud or deliberate concealment. And that involves the limitation period starting to run at the time they are in the same position as they would have been if they'd been any other kind of claim.
Yes. My lord, I understand that. I would say this, the only real answer to that is the one that was given implicitly by Lord Justice Males in OTC Computers or OT Computers.
Right, but that's not a case that's not a case that decides this point.
Not at all. But the principle that he's appealing to, he says it's unnecessary to be too sympathetic to parties who behaved in either this way with fraud.
I mean, that's all very interesting, but I mean, with great respect to Lord Justice Males, he wasn't deciding the full ramifications of FII.
My Lord, that's right. And so I'm not going to take that point any further. That's why we say in principle that is our position. A second element of this is that we say also that in this particular case, on the facts, it falls on the fraud side of the line in view of the explicit unconscionability that forms part of the factual context. Now, we have gone in some detail to the situation of Infineon, and I'll expand on that in relation to Ms. Ford's submissions shortly. There's one point to pick up immediately concerning Renesas and what Mr. Jowl said, because he made the point in his submissions that Renesas says it was never asked about the participation in a cartel by Gemalto, unlike Infineon, and it never actively denied it. That is true, that it didn't do those things. We refer to the different element of unconscionable conduct there, which was specifically made a finding by the Commission in its decision and is referred to by us in our statement of case on limitation and in the amended particulars. And that is that Renesas was one of the very companies that the Commission found had been deliberately covering up the price fixing as part of the factual matrix of this case. And just to give you that reference again quickly, it is in SBB in the supplemental bundle at tab 6, where you should have the Commission decision, and it was recital 115. It's referred to in two subsequent recitals I took you to yesterday, where the Commission is examining an internal Renesas email. And you'll recall that about 5 lines up from the bottom of that paragraph, as the conclusion to his email report, X asked the recipients to dispose of the email from their computers. After reading it, please erase completely this mail from your computer. Thanks for understanding. So they did engage in that form of active, conscious concealment of what they were doing. So merely an undisclosed coordination.
That's sort of redolent of Lord Denning's famous observation going back in the 60s. W.H. Smith, the
Yes.
price fixers don't shout about their cartel from the hills, but they whisper it in basements.
Yes. Smoke-filled rooms.
Yeah.
Yes. Yes. And in this case, it was not just whispering.
Silence isn't necessarily golden.
Yes. In this case, it wasn't merely being silent. It was actually saying to the counterpart, please erase completely what you're saying. So there was something further there. There was an active step taken. So, my Lord, that's all I do wish to say about that preliminary observation. And I make it because, quite apart from the client's interest in this case, I accept your Lordship's point that the Court of Appeal now does want to give a judgment which gets things right, and that needs, therefore, to be put into the mix. So I now turn to FII and would ask the court to bear with me, because this is how I say it works and how the machinery fits together. FII establishes the following 4 crucial propositions, and I'll seek to make them good in a few moments. The first is that the facts which the claimant must discover are those which constitute the essential ingredients of the cause of action, and each of those facts pick up on the debate that was being held before the short adjournment. So here, it includes the question when the claimant bought goods at cartel prices and suffered loss by being overcharged. It's essential to the claim for damages. And without perhaps needing to go directly back to the statute, you'll recall that the language of section 32(1)(b) refers to concealment of any fact relevant to the right of action.
Yes, not every fact.
No, in context, it must, well, yes. any facts that are concealed, which are essential to the cause of action, need to be unconcealed. So that if one, to pick up on my Lord Justice Birss's point before the short adjournment, if someone was to say, well, I've told you this now, or you already knew that you were a customer without the concealment, so the rest doesn't matter, that can't be right. The purpose of this provision is to ensure that anything that has been concealed is unconcealed. And in agreement with the respondents, it's because that then places the party in the same position that it would have been without the problem, which the statutory provision is concerned to address. And this proposition that the facts that you must discover are the ones which constitute the essential ingredients of the cause of action, this is at the heart of the so-called statement of claim test, because the test is about what must be known and not about the level of knowledge, which the members of the court will have seen from the case law has been treated rather vaguely and in different terms by courts in the past. The case that Mr. Jowl took you to yesterday was Mirror Group newspapers. And that made the point that one must distinguish between the essential facts, being those which are needed to establish a prima facie case, and other facts, other relevant facts, such as those which go to the question of the existence of a defence. You'll recall that was a libel case, and the question there was whether facts which go to the existence of a valid statutory libel defence were essential facts or not. And the court says no. I'll simply give you the reference without the need to go there unless your lordship wishes. It's Authorities tab 2, the judgment of Lord Justice Neal on page 8 between letters E and F. So that's the first proposition. What are the facts? The second proposition, which I'll again seek to show you from FII in a moment, is that the claimant discovers these essential facts at the point when they recognise that a worthwhile claim, that they have a worthwhile claim in damages, and not before that point. So we will be unpacking exactly what that comprises. Third proposition is that FII refers to reaching a stage when it is reasonable to investigate further. And we also talked about that consideration in court yesterday. And this is the point of having sufficient confidence in the existence of the essential facts and of recognising that you have a worthwhile claim in damages as the premise, as your starting point, which then makes it reasonable for you to investigate further facts. And by investigating further, what is meant is embarking on the preliminaries to the issue of the writ. That's how the phrase comes in my submission. And therefore, these phrases, beginning investigations or embarking on the preliminaries to the issue of a writ, do not mean conducting investigations into whether the essential facts exist in order to get to the point of recognising that you have a worthwhile claim in damages. It is the other way around. Now, in her submissions this morning, Miss Ford suggested, if I heard correctly, that the actions taken by Gemalto in 2009, remember when the news of the Dawn raid breaks, those fell into this bracket. They were beginning to investigate. They were, if one likes, embarking on the preliminaries. But they were not. The company was taking advice at that point to learn of its rights so that it could work out when it might have a worthwhile claim. And similarly, Mr. Jowl suggested in his submissions that preliminaries could include contacting a defendant after the news of an investigation is broken to ask, did you do it? And it's not that either, because that is an inquiry before you know, before you recognise that you have a worthwhile claim. And that is, in my submission, not what is meant by FII. As I say, I will go in a moment to the key paragraphs.
Can I just be clear about this? I was just looking at the judge's paragraph 54 below as to when she was analysing the submissions as to the first point in time in which it could be said time was to run. And I think she said there was some change, seemed to be some change in the defendant's position, but by the time of the hearing, it was on the basis of the information available by the time of the announcement of the SO. So it was SO plus RFIs plus press release about dawn raid plus press release about when the defendant was party to the proceedings. And it was the cumulative effect of those four. And I don't think they were saying that at any one of those steps or one of those announcements at an earlier point was sufficient revelation to dislodge the concealment.
No, I agree, and that's how I understand it as well, and how I understand the submissions to have ultimately ended up, as the judge says. What I'm referring to is what I thought I understood to be certain suggestions today, that there was some independent significance in those actions, because they were the sort of things that constituted embarking on the preliminaries or doing the investigations referred to in FII. And my construction is that that's not right. We'll go to it in just a moment, but the machinery of FII...
I suppose their concession, if it's correctly expressed in 54, would mean that it was not reasonable to conduct any preliminaries until such time as the SO was issued in 2013, and anything which went on before wasn't prejudicial to you.
Yes.
Should follow, I think.
Yes. As I understand it, what's been said is, as your lordship put it, everything that led up to that moment when the SO is issued and they find out about it helps to contribute to the formation, to the necessary formation of the belief that
the
this
jigsaw
material
is in the picture.
Yes, and so it comes into the picture for that reason, not that it constitutes something that then happens afterwards, which is...
Well, they didn't say that, but they didn't have to say that. And that wasn't the case. I mean, you can't salami slice the case and say, because they say time ran at the statement of objections, they are saying that time had not begun running before. It may have done, it may not. That's not the case that they were putting and asking the judge to decide. I mean, it's a non sequitur to say, which is their case, that time did not start to run when the RFI was...
Well, my lord, I see Miss Ford is on her feet. She can clarify whether she is saying that time started to run at the earlier point.
Well, she's not been asked to say that. Well, that's not her case.
My lord, I was simply going to draw attention to the words "at least by then" in the third line from the bottom. The submission that we made, which is recorded in the judgment, is that at least by then Gemalto had sufficient information to identify all of the essential elements of the cartel. There was an exchange between myself and Mrs. Justice Bacon as to whether we put the date any earlier, and my submission was it is not for us to specify the particular date. We simply say that at least by that point the test was satisfied.
My lord,
I think that's a yes.
That's a yes. So content to proceed on that basis. What been exploring then with my Lord Justice Green is what the significance is in principle of the earlier actions in 2009, how those relate to the FII test. And my submission is that those are not the investigations or the embarking on preliminaries, which you will see the judgment.
Said that. Yeah.
So the fourth point, I said that there were four, is about the concept of recognition that there's a worthwhile claim and what it implies. And my Lord the Master of the Rolls has crisply already summarised my position, if I may say so. But to be quite clear, the concept of recognising that you have a worthwhile claim implies that the claimant has a reasonable belief that its assertions about these essential facts are correct. In other words,
That's not what you said yesterday.
well, this is I'm making crystal clear that this is our position. I'll put it in the way which I hope does also reflect what I said before, but this is it. In other words, a reasonable person could conclude on the basis of the available material that there has more likely than not been an infringement. And by an infringement, I'm using the term as shorthand to refer to the essential ingredients and each of them of the tort, what you would need in order to have the platform for pleading a case. And now I will seek to make those four propositions good by reference to the judgment. So if you open FII, so authority is tab 25.
I think we know where.
Yes. And all I'm going to do is draw your attention to paragraphs that, again, my lord, you are also by now very well familiar with. So on the first proposition, which is the facts that the claimants must discover are those that constitute the essential ingredients of the cause of action, the source for that is paragraph 195 on page 89, and you'll see what's said from 3 lines down from letter B, where the judges say the former line of authority proceeds on the basis that the commencement of the limitation period is postponed until the claimant knows, actually or constructively, the essential facts, not one or more, but the essential facts on which the cause of action is based, with sufficient confidence to justify embarking on the preliminaries to the issue of a writ. And we know from the first sentence of 196 below that the court approves that and says only the former line of authority is consistent with the rationale of limitation periods. It's therefore this line of authority which is being endorsed. That is for the first proposition. For the second, which is that the claimant can be taken to discover the essential facts when they reach the point of having sufficient confidence in their existence or recognising that they have a worthwhile claim in damages. You see that also from paragraph 195, just under letter B, and I've read out already the relevant words. The former line of authority proceeds on the basis that there's postponement until you know actually or constructively the essential facts with sufficient confidence to justify embarking on the preliminaries. And then it continues, the dissenting judgment of Lord Brown in Deutsche Morgan Grenfell is consistent with that approach. Time doesn't begin to run until the claimant knows actually or constructively that he made a mistake, that being an essential ingredient of the cause of action, to the standard that a worthwhile claim arises. Third point.
Can I just stop you and ask you what you mean by those phrases? As I understand them in context, the concept of sufficient confidence in embarking and worthwhile are both about, if you like, the economic benefit of investing in the preliminaries. So you've got to get to a point in which it is worthwhile, or you're sufficiently confident to take the procedure forward to investigate. So there's almost a cost-benefit analysis at that point. And I think that rather ties in with some of the things said later in 190 and 192 about different types of claimant. But is that what we're really focusing upon? You've got to get to a point where you, in your capacity, in whatever business you're in, have taken a rational decision that the cost of going forward is likely to be met with a proper reward.
My lord, in overall terms, absolutely, and that is exactly where I'm going in a moment. guided by the Master of the Rolls point yesterday, that this court is concerned to ensure that a rule or principle that it articulates is something that is both workable and sensible and efficient in practice. And I do want to address those dimensions. So absolutely that is the perspective that I'm seeking to adopt.
That's what comes out, I think it's 209 subparagraph 2.
Yes, yes, absolutely. The only qualification that I would make is that I would split worthwhile claim from sufficient confidence to justify embarking on the preliminaries. They're obviously related, but as I understand this judgment, the starting point is you appreciate or recognise that you have a worthwhile claim.
But worthwhile is worth the while. Worth is what you get back,
Yes,
the
yes.
while is the cost.
Yes, a worthwhile claim. My lord, that's absolutely right. And in fact, nobody's actually unpacked the meaning of worthwhile. But yes, worthwhile does mean something which, if you were to commence it, the reward would bear the risk.
But it may mean that, but certainly for my part, I think that is over-interpreting Lord Brown's dissenting judgment by a very large margin.
Right.
I think this is not all about economics. This is about claims, a limitation period starting. And I don't think anybody would have thought this is about an economic balance between risk and reward. That simply is not how limitation periods start, and there's nothing in this judgment except the use of words from those cases and the use of a word worthwhile that really does it except justify. But justification is on the basis that you've got a worthwhile claim, which means a claim that has some prospect of success, and the question is what level.
My lord, that admonition, if I may say so, is very well taken, because I speak only for myself in that debate, and I'm sure Lord Justice Green is in exactly the same category. There's no question of a calculus here being applied whatsoever.
And we must not construe this judgment as a deed. You know, this is a reasoned judgment, but it's not intended to be construed as a deed.
No.
And actually there are, as we have had in quite clearly, there are some inconsistencies and use of language that is slightly inappropriate when you consider it in very great detail. We've got to get to what this is intending to mean. And, you know, at some point you're going to tell me, I don't think you do depart from what you said yesterday, which is your fourth proposition.
Coming on to that, but if I may just complete the point here in answer to my Lord Justice Green, we agree that when the court is referring to sufficient confidence to justify embarking on the preliminaries, although there's no detailed calculus involved, it does mean from the court's perspective and from a claimant, someone seeking to understand what the section means, that you have to consider that it is, in my Lord Justice Green's words, worthwhile doing that. And that is a point that I'm going to pick up in a moment, to consider that in the matrix of this case, where what you know about is
all it's
there.
about, Mr. Turner, is the level of knowledge.
Yes.
Because you must remember the words. The limitation period is postponed until the claimant knows something. And what the qualification qualifies knows.
Yes.
Nothing else. And therefore it's not demanding this incredibly complex analysis that we're beginning to get into.
Well,
If it were,
as I say,
if it were, it would be a most impracticable test, and that's what they say at point 10. It's not.
yes, my Lord, I understand that, and in no way am I seeking to say that this will be a complicated analysis at all. So if I may, then I'll turn, because I'm going to go to the third of four submissions. The third that I opened with before was the recognition that there's a worthwhile claim in damages is then what makes it reasonable to begin to investigate further other matters with a view to the issue of the writ, the claim.
You put completely new words on what they say, but yes.
Well, if we now go back to paragraph 192, which is the example that they gave, that I referred to yesterday, outset, that's the running down example. And that shows you what they had in mind about the difference between the appreciation of the worthwhile claim and the later stage. And it was the point that when certain events are known to you, which in that case were the running down events, there are then certain further things that need to be done procedurally, which involve time and expense, before you can issue a claim. And their point is that those should not affect the limitation period starting to run. And if it were the case that time starts to run, think of it this way, just as soon as a claimant becomes aware of a reason to investigate whether the essential elements of the infringement exist in the first place. I now understand it's possible that there's a cartel, by way of random example. The whole purpose of the statutory section is subverted because time might expire before a claimant can fairly bring its claim. Because I'm now at the point time is starting to run against me, and I'm now seeking to investigate over a course of time whether those essential elements of my claim exist or not. And that is the very problem that time might run out against me, which this section is intended to prevent.
Why is that right? I mean, the point of concealment is that, of course, if it's concealed, you can't go and see your lawyer at all. Once the concealment has gone, once the concealment has disappeared, you can go and instruct your lawyer. It's worthwhile to go and see a lawyer about it because it's no longer being concealed, and you have 6 years to sort it out. I don't understand why what you said is right at all.
Because the issue is what has been concealed. So I'll develop this in a moment. But here, various suppliers have got together during a particular time frame to fix prices of goods that are supplied to you and thereby to overcharge you for them. It is only when you know of those facts, not merely the possibility that it will be found that there was a cartel between various suppliers, that you then know that you recognise that you have a worthwhile claim. And it is when you recognise you have a worthwhile claim that you can then go on to say, I now need to know certain other things, and I'll come to this in a moment, to carry out certain further investigations to see if I can plead a case.
Well, I think you're back on the over-interpretation. I mean, the analogy in 192 tells you that that's precisely the opposite of what he's saying.
Well, my lord...
we take the example in 192 of the person who ran out in front of the car. He doesn't have a worthwhile claim. He actually doesn't have one. But the limitation for the claim which he brings, which he's going to lose, still starts to run.
My lord, that example is taking the point that there's a difference between when the events occur, which mean that time starts to run, and the slightly later date, regardless of whether you run out of time in limitation, because it doesn't matter for that example, when you are in the position to actually plead your case. And the judges are making the point that between those events occurring, which in that case you directly apprehend because you're the victim, and the later date when you are able to plead a case, there will be a period of time that needs to elapse. That's the only point.
Yes, but the point is the limitation period started before you got to a state where you could plead your case.
That's right.
Example. But you're saying for the concealment situation, the limitation period doesn't start to run until you can plead a case.
My lord, no, I certainly don't mean that. What I mean is, this is what I mean. In the concealment situation, the time starts to run, not when you can actually plead your case, because there are things that will need to be done, but as in this example, when you are aware of the key events which constitute the essential ingredients of the case.
Well,
So
see, the reason why that is wrong, if I may respectfully put to you, is because of all the rest of their judgment. If you look at point 6, consistent with discovery in another statutory context, they look at the tax case of Earl Beatty, and there they say, when the commissioner issues a discovery assessment, the commissioner finds out or thinks they found out the existence of an omission or other error. It is not, the commission finds out or thinks they've found out an error. It is not necessary for them to approve the matter to its depth or to define precisely the ground on which they made the assessments. In other words, no investigation is necessary. They just realise there's an error. The error's been concealed. Now, in our case, it's no longer concealed, and the time starts. They've got 6 years, just like the person who runs out in the pedestrian crossing. They've got a long time to deal with all that probing the matter to its depths and defining precisely the ground for the claim. So, I mean, when you say there's now these 2 stages in the investigation process, I mean, that's precisely what he's not saying.
Well, my lord, in my submission, that
Well,
certainly we're not saying that you need to have achieved certainty in relation to anything, including those essential elements, before you can begin your claim, before the time starts to run. I'm putting the point of pleading later than that point.
No, but the time starts to run. I mean, the point that is so basic to this is time starts to run to put you in the position that you would have been in if nothing had been concealed. Right? So what's the vice? This section is, the vice in this section is that some frauds are concealed. You know, if I go into your bank account secretly and take £100 out, you may not know because you may have hundreds of thousands, Mr. Turner, in your bank account, and you may not notice it. So I've done that deliberately in order to conceal the fact that I've only taken £100, which is a fraud, right? Now, all you've got to know is that somebody's been hacking into your bank account. You don't have to know that it was me and it was 100 quid. And, well, you might have to know it was me.
You do have to know.
You may have to know it was me. But the point I'm making is you don't have to know how it was done or any more about the detail or all the things you would plead. He's saying to be put in the position as if it had been done overtly when it was done covertly.
Yes, my lord, I'm going to give you one reference to try to make this particular point good in a moment.
Okay.
But I would say in relation to that is that your lordship's example there does recall the difference between the bare minimum facts which you do need to have recognition amount to a worthwhile claim, and other facts which are also relevant to bringing a case. For example, in the Mirror Group newspapers case that Mr. Zhao referred to, you might want to investigate whether there is a valid defence in the libel context, or in our case, whether there was a crisis cartel or something that justifies the behaviour that was taken, something of that kind. Those you leave to one side. You focus only on the bare essentials, and you do not ask for certainty. You only ask for enough to make it worthwhile to bring a case, and to give you sufficient confidence to embark on the preliminaries, which later takes you to the point where you can say, I'm now able to plead the case. And if I may give you a reference that may help with this, the sequence that I'm referring to and what's meant by knowing enough to make it reasonable to begin to investigate is made clear by the Supreme Court in the separate decision of AB in the Ministry of Defence, which you know that they refer to several times in FII. It's discussed with approval, for example, at paragraph 190. We can just pick that up. It's in tab 10 of the authorities. sure whether we've looked at this
I'm sure we
explicitly
have.
yet at all, but it was referred to in FII with approval. They referred to paragraphs 11 and 12, which are where Lord Wilson was dealing with the question of what's the right level of knowledge. And I want to go to Lord Phillips' opinion.
I mean, this is a Section 14A case, isn't it?
It is, which the court goes on to say raises analogous principles in FII, so they draw on it as relevant to the analysis of Section 32. And if we go in it to page 49 of the Opus version, which is Lord Phillips' opinion, you have there his discussion of something that Lord Hoffman had said that he wants to clarify for the purpose of understanding how it works in limitation. And he says at letter C that he, Lord Hoffman, went on to make a statement that, if not read with care, is capable of misleading. He said, 449, the purpose of section 14.1, as Lord Donaldson pointed out in Halford and Brooks, is to determine the moment at which the plaintiff knows enough to make it reasonable for him to begin to investigate whether or not they've got a case against the defendants. So he takes that as the matter that he wants to clarify. And then if you go down to letter E, under that quote, the statement that time begins to run when the plaintiff knows enough to make it reasonable for him to begin to investigate whether or not he's got a case against the defendant relates to an investigation whether, having regard to the knowledge of attributability that has been acquired, a case against the defendant exists. The passage should not be read as holding that time begins to run as soon as a claimant knows enough to make it reasonable to make a further investigation of the facts relevant to attributability. And just to remind your lordships, attributability is a concept which is defined back in this judgment at page 13, letter E, in the judgment of Lord Wilson. And
what does it mean?
What it means is that you know that the injury suffered in the personal injury context is attributable in whole or part to the act or omission of the defendant, which is alleged to constitute the negligence. But what he is saying here is he's clarifying this point by saying that it's only once you have that essential fact pocketed that you then go on to begin to investigate all of the other facts and matters you need to look into before you can plead a case.
Yeah, I mean, if you had a pain in your leg and you weren't sure whether it was caused by having been knocked by a car or having gout or whatever, you'd have to be sure it was being knocked by the car before it would be worth investigating whether you had a claim. I mean, that's a silly example, but
yes.
But I mean, that's nothing to do with this case.
Well, I should hope that it is not. But my point is that the relevance to this case is that if one is in a position, and we're taking the case before us, that you know that a statement of objections has been served because you received the press notices, so you know that there's a possibility that they're going to go on in their investigation to find an infringement. Our case is that is not a point at which you already recognise that a worthwhile claim arises, and it is not a point when you can say with sufficient confidence, I now go on to investigate the various things I need to do as a claimant in this field to put together a plea document. And that's what I'm going to develop in just a moment a little bit more closely. But if I may, I'll conclude because of the time, but it's very important to go through this with the fourth point that your Lordship asked me about. The fourth proposition was that you get this from FII. Having sufficient confidence in the existence of the essential facts, or the recognition that there's a worthwhile claim implies that the claimant has a reasonable belief that the assertions are correct, or that a reasonable person could believe it's more likely than not that these essential ingredients are present. Mr. Jowl referred to the section of FII commencing at paragraph 199 under the heading Discovery and Ascertainment of Truth, and Miss Ford earlier also went to paragraph 201 and the proposition there about the commencement of proceedings without being liable to be struck out. And my submission is that it is necessary to read the reasoning in this judgment, as your lordship rightly says, not as though it's a deed, but taking it as a whole. And I come back to the court's summary of the position it has arrived at on the level of knowledge in paragraph 213 on page 95 above letter E. And 213, paragraph 213, subparagraph 14, over the page, on page 96, letter F, articulates in clear terms, in the last 4 lines, the claimant cannot be required to have ascertained the truth in order for a limitation period to apply. We agree. That's too high a level of knowledge. Consistently with authorities concerned with analogous provisions of the 1980 Act, a reasonable belief will normally suffice. And that is why I have been using the language here of reasonable belief. And now I would ask the court to bear with me and say that you can test it by asking this. Does Gemalto have a reasonable belief in the essential ingredients of its cause of action based on the information in this press release of the Commission and what's preceded it, such as would justify it going out to incur costs and embarking on the preliminaries to the issue of a writ? And it's only to that extent that I'm proceeding on the economic path. And I'm just asking whether, as a matter of qualitative impression, in these circumstances, is it reasonable to expect somebody in this position to go out to incur these costs or not? Parties have not exercised rights of defence or been heard. So the client will ask the lawyers, who do I sue? Which entities in these groups? And they will also ask, which products do I sue in relation to? Which geography? Is it all of the EEA or certain countries? And critically, for sales to us at an overcharge, in which time period are we concerned about? The client discusses these matters with the lawyer. And they are all the essential elements of the cause of action. The reasonable answer for a responsible lawyer to give to a client is that you've got to await the Commission's decision to see what the findings are. And it's at that point that the private damages claimant can sensibly put in hand the investigations that do constitute embarking on the preliminaries to the issue of the writ. And in my submission, it's wrong to suggest that that work can or should sensibly be done while the Commission's investigation is ongoing and while its preliminary view may well, which is its phrase, may well change, may well be abandoned or materially narrowed.
Can I ask this to test that proposition? I wonder whether the lawyer's advice prior to Mrs. Justice Bacon's judgment might have been, actually limitation's a bit of a complex field, you're probably safe. In the light of a High Court judgment which says no, you need to act on a cautionary basis, whack in the proceedings now and then you're safe, lawyers would then take a quite different view. I mean, is it really almost a matter of legal certainty as to what the law is? If the signal is sent out, when the SO's out, you put in your proceedings, no court's going to strike it out, you're safe, don't worry. wouldn't a lawyer then say, well, you can wait for a few years, but frankly, safest thing is issue proceedings and then apply for a stay?
My lord, there are two answers to that. The first is, without myself giving evidence about what the reaction has been to the first instance judgment, one can quite readily see it does send out a signal. My gosh, it may well be now that we have to do things, and you can see that clients will be approaching their lawyers and saying, what can we do? And the second point is that they therefore now do ask these questions. What do we do? Which products are we talking about? Which time period are we talking about? And that is why my second point does really lie, because the lawyers do have to say, we don't know yet. And certainly here,
say we don't know, but let's act on a cautious basis. That's part of legal advice. Be cautious. There's no great cost in issuing proceedings and either agreeing a stay or getting a stay from the court. You're then safe.
My lord, there are significant costs. You do have to decide what are the parameters of each of these that you put down in the pleading. You do responsibly, big companies with their lawyers need to work out what is the framework in which I'm going to put a claim into the court. And I'll come in a moment to the question that your lordship rightly does raise again, which is, of course, it can be stayed.
Or you can, the advice might be, sit on it for a few years, see what the commission decision is, but all events get it in 6 years from the SO.
Well,
Law doesn't have to be certain. Lawyer doesn't have to be certain. They just have to say this is cautious and prudent advice.
Get something in and wait a few years. Well,
no, or just wait a few years.
Or just if it's just wait a few years, and I'll come to this in a moment. There's an implication there, which is that the real event that gives you what you need to incur the cost to justify taking these steps is the decision. Really, we need to recognise that is the case in this situation, and that is my practical point.
The problem with that is that, as I mentioned this morning, Section 32 was not written for competition cases. Section 32 is about every kind of case. And it may be that if you were writing a limitation regime for competition cases in the European Union, you would say time runs when the decision is out. But that really is not anything to do with this case, because Section 32 has to have effect for every kind of case in the world.
My lord, I entirely agree with that. What I'm seeking to do is to say that the rule, which is a general rule applicable throughout the world, applied in this competition law context, needs to be understood as having this outcome, not the one that's contended for on the other side. And I'm drawing attention to the genuine practical reasons why this is true.
Yeah.
And it's here that I come back to the point that Mr. Jowl took issue with at the outset yesterday afternoon, that the Commission itself does not and would not say we have a reasonable belief in the infringement having taken place, which is what I said at the outset, immediately contested on the other side. My submission was correct. He took you to the best practice note, which I'd ask you to look up again, please. Authorities, tab 53, paragraph 82. Paragraph 82 is on page 16. And you'll recall there, it refers to the SO setting out the preliminary position of the Commission on the alleged infringement. It doesn't refer to the Commission having a reasonable or any belief in the outcome of its investigation. It needs to be read in conjunction with the earlier paragraph on the previous page, page 15, which I'd taken you to, paragraph 77. And this is where the Commission strongly emphasises the absence of prejudgment of the final outcome and, in its words, that the process may well lead to the closing of the case. That's how it understands its own process. And this point about the particular nature of the commission procedure, which is the fabric of this case, is reinforced by reference to the next document in the bundle, which Renesis referred to in its skeleton argument. And that's tab 54, the Commission's own Manual of Procedures, which is a very large document in which the Commission sets out in great detail how it approaches each of these enforcement steps. And we have quoted there on page 3 one part, and this explains why it is that the statement of objections is only authorised by the Commission President and the Legal Service. It's the purpose of this section 2212, the special case of the statement of objections. And if you read in that paragraph 31, internal paragraph 44, for the statement of objections, the proposed decision foresees a mechanism under which the President of the Commission intervenes as guarantor both of the principle of collegiality and of the credibility of the Commission as an impartial and objective enforcer of the law. So that's why the President gets involved. And then at 47, given the purely preparatory and provisional nature of a statement of objections, it wouldn't be appropriate to subject its adoption to the prior approval of services other than the legal service. And this shows how this particular machinery in the European system is approached. And it's particularly significant because yesterday, Mr. Jowl also drew what at first sight sounded like a good analogy between the issue of an SO and the bringing of a formal criminal charge, an indictment under English law.
Before my learned friend goes on to that, could I just invite the court to please continue reading in paragraph 47, the quotation there, where it explains why other departments, other than the legal service, are not to have involvement.
My Lord, I'm very happy for you to take a minute to do that, and then I'll continue.
Yeah.
Now, well, if we put that away, the analogy of Mr. Jowls yesterday, towards the end of the afternoon, was misguided. Because in direct contrast with the position, with the issue of a statement of objections, and your lordships will...
Does any of this matter? You accepted yesterday that an SO is produced after a detailed investigation and at least leads to a case to answer.
Yes.
Does a claimant need any more than that? Never mind whether it's criminal, non-criminal, preparatory, provisional, final, leading on the way to a decision, leading to an abandonment. At that point in time, the Commission, an expert body after an investigation, thinks there's a case to answer.
Yes.
I mean, if you take it at that level, then you say the answer, that's not enough. They say it is. I mean, I suspect that's at least common ground. Everything else is really just descriptors.
Yes.
But that's the essence.
My Lord,
case to
my Lord, you're right. That was my very first point in opening yesterday, is that we say that what a claimant apprehends when an SO is issued is that the competition authority considers that there is a case to answer and that it is neutral as to belief as to whether the infringement itself has occurred. What the statute we're concerned with is asking whether the claimant reasonably is in a position to recognise the second point, that the infringement has occurred. And it was for that reason that I was saying that there is this disconnect.
A case to answer is the opposite of no case to answer. And even in civil law, you're entitled to strike a claim out if there's no case to answer, but not if there is a case to answer.
My Lord, yes. May I just complete this point, and then I will continue. The Code for Crown Prosecutors, your Lordships ought to have been supplied with copies of that. I don't know if paper copies reached you. It was supplied to my friends this morning. And
An electronic copy.
there are paper copies. If you,
I don't use paper, Mr. Quintana. I think that's
Shall
pretty
I
well
email it
known.
to you? I've got an
You can email it to me. Thank you.
Well, I'm very grateful, my lord.
I'm going to read it in paper.
That's sad.
In direct contrast with what you have seen about the way in which the Commission approaches the issue of an ESO and its significance.
I've actually got it. You did, to be fair to you, you did send it to me electronically. Thank you.
I'm obliged.
I take it all back.
There's just two short bits in this that are pretty well known, but they're important given the analogy that was drawn. Paragraph 4.5, you have that. Prosecutors should only take such a decision when they're satisfied the broad extent of the criminality has been determined and they're able to make a fully informed assessment of the public interest. If prosecutors don't have sufficient interest to take such a decision, the investigation should continue. So that's the first principle that guides how the Crown Prosecution Service approaches it. And then 4.7, the bottom of that page, if you have it in paper, is that the finding that there is a realistic prospect of conviction is based on the prosecutor's objective assessment of the evidence, including the impact of any defence. Remember, in the SO context, you haven't got to exercise the right to defence yet, and any other information that the suspect has put forward or on which they might rely. It means that an objective, impartial and reasonable jury or bench or judge hearing the case alone, properly directed in accordance with the law, is more likely than not to convict. That's what the code says, and this is therefore the 51% rule that applies in the case of a domestic indictment. And I'm drawing that to your attention because in case you saw a perfect analogy with the example given by Mr. Jowl,
We don't.
It's
don't
not.
worry.
I'm sorry, my lord?
This isn't. We're not talking about crime. If this were a criminal case, the Commission couldn't prosecute in front of itself and then sentence. And that's why you have to have proper rights of appeal, and that was the Court of Human Rights in Menalini and all those sorts of cases.
Menarini, yes.
Menarini. But for my part, I don't see much advantage in the criminal analogy. I mean, the Commission proceedings are what they are. It's a case to answer. It may collapse, it may go ahead, it may expand, it may contract, there are rights of defence, and then there's proper rights of appeal. I don't think there's much we really extract from an analogy with criminal proceedings in this country.
My lord, I'm grateful, but as the point was made, that's the response.
You made your reply. Now we are sort of getting into the further reaches of this case. So.
In a case like ours, my lord, where the claimant has got no separate grounds to infer cartel practices beyond the Commission's investigation itself, the fact that the statement of objections has been issued, as in this case, does not give a third party on the outside, Gemalto, recognition that it has a worthwhile cartel damages case against A and B and C in relation to this period when it was overcharged. That's the point. And the position is underscored when the objective context that the court needs to bear in mind in this litigation is that prices are falling, the claimant is securing a good deal from its suppliers in the negotiations, and on top of that, the main supplier, the largest one, tells you it's carried out an exhaustive internal investigation, it's revealed nothing. And it's for all of those reasons in totality, which are all objective facts, that a reasonable party in the position of this claimant does not recognise that it has a worthwhile claim prior to the infringement decision. My lords, with that, in view of the time, I turn to the judicial policy point, which I've been trailing. Mr. Jowl said yesterday that there's nothing in it, because even if a claim is lodged on the strength of knowing that an SO is issued, and it's then stayed to await the infringement decision, there'll still probably be some part of the 6-year period remaining, and my Lord Master of Rolls says 6 years is a long time, after the Commission's position is finalised one way or the other. No decision, a narrower decision, or the full infringement decision. And that would provide you the breathing space during which you can actually embark on the preliminaries to the issue of a writ. the judicial policy point is sound. Because if the principle really is that claimants are taken to have discovered concealment of a cartel at the point they learn an SO has been issued, it does have a number of very real adverse consequences for practice in this field in the English courts. It means that if potential claimants wait until the final position of the Commission emerges, which could be 3 years or 4 years or more, because as certainly my Lord Justice Green well knows, there's not just the statement of objections. In these cases, you then get the supplemental statement of objections, you get letters of facts, you have further rounds of representation, and all of that. There may be little time remaining within which to accomplish all the necessary preparations for issuing a writ in a complicated international conspiracy case. And I must draw attention, which I sought to do earlier briefly, to the implicit assumption which lies behind the thought process, both of the judge below and of Mr. Jowl. The implicit assumption, when one says you can always bring it on a protective basis and stay it, is that it isn't reasonable to expect a damages claimant to embark on the preliminaries until the Commission's decision has arrived. Because that thought process tells one that it is the news of the adoption of the Commission's decision which marks the true point when time should start to run, not before. And if, on the other hand, potential claimants who are worried that the clock is ticking respond to that pressure by embarking on these preliminaries to issuing a writ, then, as debated with my Lord Justice Green, it is liable to result in wasteful and premature expenditure of money. And it is not an outcome that this court should sanction. And to return to the point that was canvassed yesterday with my Lord Justice Green, if the claimant does lodge a claim on the back of news in the press of a statement of objections, only to find later that the scope of the investigation has been cut down in a material way or even dropped, in practice they will need to discontinue the claim and pay the costs. And it is not a trivial consideration. If the rule is that in what is effectively, this is a very clear case, a follow-on action, no other separate basis for a claimant to infer that there is a problem, in this sort of case, that time starts to run against you from the date of announcement of a statement of objections, it won't lead to certainty, and it won't be conducive to the efficient working of the legal system in this area. It will lead to wasteful expense. Ms. Ford said a little earlier today that a claimant who lodges a case on the strength of a statement of objections can do useful things. They can seek disclosure in parallel with the ongoing investigation. But in my submission, that is not realistic. It's duplicative, it's inefficient, and it might even interfere with the European Commission's ongoing investigation itself. And to pick up her second point, if the statement of objections is abandoned by the Commission, they drop the case, it's untenable to suggest that a claimant with no other source of knowledge would or could press on. They would have to discontinue and pay costs. And that is why I say that the judicial policy point powerfully reinforces the correctness of our appeal on ground one. The next point, and I'll try to pick up the pace, I'm grateful for the court's indulgence, I'm very conscious of the time. The next point I need to cover is Mr. Jowl's survey of the Toshiba carrier case, which he took time on yesterday. You'll remember the decision of Chancellor Morit. And he drew on that as authority that in a cartel damages claim, the courts allow a measure of generosity to the claimants. And he seemed to suggest that that generosity equally extends to claimants who rely on the news that an SO has been issued as their basis for lodging a claim. But the point in Toshiba carrier is entirely different from the problem which now confronts this court. The ratio there was that in circumstances where the wider corporate group has been found guilty, it's been made the subject of a commission infringement decision, it's acceptable for claimants at the initial pleading stage to infer that the relevant selling subsidiaries in the group were wrapped up in the cartel. I don't know if I need to make that good, but if you turn very briefly to the case.
I don't think you do, because that's what happened in the case. He showed us that. So why not?
Well, that's what happened. What the Chancellor says, and I'll merely give you the reference, paragraph 51, is if the wider corporate group is the subject of this infringement decision, it's reasonable at the first stage to assume that the selling subsidiary which sold the goods to you was in the cartel.
Yeah.
And we're not in a situation where the Commission has made any infringement decision at this point against these defendant groups.
Yeah.
But that was the bedrock which enabled them to go ahead in that case. That's that one. The next point of reply, and I'm conscious of what the court said to me about this yesterday, so I'll be guided by you, is Mr. Jowell's reliance on the judgment of Mr. Justice Sales in Nokia. It's also...
Yeah.
The
We've
question
surely heard
is,
enough about Nokia.
I'm sorry, Mother?
We've surely heard enough about Nokia.
Well, if all members of the court are agreed, then I...
Tell us the proposition you think we ought to be agreed on.
Okay.
And if necessary, give us the reference.
I'll do that. The suggestion was, here you've got a case where the claimants lodged the original particulars of claim based largely on information in the Commission press release announcing the SO, and where the court, Mr. Justice Sales, saw no problem with it. And my submission is that both parts of that submission are not right. One, because it was manifest that the claimant didn't base itself, even largely, on information in the press release, when you read that judgment. And secondly, a point I made yesterday, because Mr. Justice Sales didn't even consider the point. And I'll give you the references very briefly. Paragraph 17, right at the outset, where the judge said over a considerable period of time there have been concerns on the part of regulators and customers about possible anti-competitive cartel practices, totally different from our case. My Lord Justice Green knows the history. So there was an immediate reference to a body of material suggesting cartel-based practices outside the four corners of the Commission investigation. And then what I was going to do was to show you, if you look at the particulars of claim that were pleaded in that case, that Mr. Justice Sales sets out, it's quite clear there's a lot
Beyond
of...
the facts, it was much fuller than just an SO. There was evidence from all over the world.
Yes, and he actually sets out the relevant text of the SO, and you can see that there's a lot more than has come from that document immediately. Beyond that, there was a...
And to the last point, it wasn't a case about limitation, it was just a strikeout case on the ordinary test.
It was, and this exactly, which is what also Mr. Justice Snowden, as he then was, said in the later case of federal deposit, and it wasn't an issue. It wasn't an issue. And finally, for completeness, it was said, well, although some of the parties in Nokia had pleaded guilty to conspiracy before the Department of Justice, not all of them had. And some of them were just under investigation by the DOJ or the Commission. Well, in fact, as again, everyone probably knows, it's a matter of public record that almost all of them had pleaded guilty. One of them was an amnesty party, Samsung. One was already indicted and subsequently found guilty. And it was a far different case from the present one. I shan't go into it any further, but that...
I think we got to it being a far different case from this one yesterday morning.
Well, my Lord, it's worth nonetheless me making these points because it was one of the planks of the judge below's reasoning. She referred to that and she said it strongly, or it supported her analysis. As she said also did Mr. Justice Foxton in Granville. And again, I won't go into that. I'll merely give you the references. But it was another case, actually an even stronger case, where there was a vast amount of additional evidence available beyond the Commission investigation. all kinds of finding of guilt, international conspiracy, and I refer you to paragraph 63, 64, 67, 70 and 75. And I've already taken you to one part of the judge's reasoning in paragraph 97, where Mrs. Justice Bacon said, well, this is the sort of thing that gives me support in this case, and it doesn't. It was very different. So without taking any more time on that, those cases and that basis for support of the judge's reasoning do fall away. So then I come to the remaining points by way of sweep up. First, in conclusion today, Mr. Jowl referred to the federal deposit case, Mr. Justice Snowden, and he said, well, that was a case where there's recognition. This is the manipulation of LIBOR, of the generosity allowed to the claimants in precisely this sort of case. And that was exactly the point made by Defendants Counsel to Mr. Justice Snowden, and he pushed back and gave the response that that consideration is tempered, referring to Mr. Justice Sales in Nokia, by considerations of the protections that defendants enjoy in pleadings. And one of those protections was the need in a case involving fraud, which that case did inherently on the facts, although it was a cartel case, to have a solid foundation in the evidence. And my point very simply is that for reasons that have already been trailed, this is not a fraud case where people were actively deceived. It is an unconscionability, deliberate concealment case where the same solid foundation in the evidence before you plead something as serious as a cartel, international cartel damages case is merited. Now I move to some sweep-up points in relation to Miss Ford. Miss Ford spent time this morning referring to elements of the facts about how Gemalto did take steps in 2009. She took you to some of those documents. But this was not, to come back to my point at the outset, equivalent to relevant points constituting embarking on preliminaries for the purpose of Section 32. It was a wholly understandable, and in terms of Section 32, wholly anodyne expression of interest by the claimant in what was going on and what its legal rights were. They were very clear in writing, leave aside what the witnesses actually said, about two things. First, the crime remains to be demonstrated. And secondly, they consider that if the investigation turns sour, which was their phrase, then they may consider suing their suppliers. And that cannot be dismissed, as I indicated yesterday, as subjective, because it indicates how reasonable business people in the position of Gemalto respond. Ms. Ford said that they were taking active steps to prepare for the possibility of bringing a claim. I can agree with that, but what I say is that that is of no value to the decision under Section 32. As respects the request for further information in 2012, the two of them, Ms. Ford submitted that they lead to the inference that the time period addressed by those documents was the time period covered by the Commission investigation. If she meant that that was the suspected infringement period, that cannot be right. The point that was not covered, but which we made in writing, which I adumbrated in opening, is that questions posed at the information gathering stage need not reflect the period when a cartel is suspected. They could equally refer to comparator periods before or after an infringement. For example, you have cases where a leniency applicant gives you a great deal of information about a particular period, and then one goes out and asks people in the market about comparator period as part of your information gathering to understand the full context of the market. It is crucial to their case and to the supportability of the judge's decision below that you can draw an inference from that factual information request about the time period when a cartel took place. And for that reason alone, you cannot do that. You cannot say from that early information request that it is possible to infer that that is when you were overcharged as the result of a cartel. Now, Ms. Ford said that there was no document, secondly, indicating what response was received. She was pointing out that Gemalto made certain inquiries and asked at least one other supplier. We see that there's been a statement of objections. What do you say about it? There was a document, purely to correct the record, which did indicate the position there. You may recall she took you to an email in which the chief executive of the claimant company writes to the chief executive of another company, I think NXP, and says, I've seen that there's been this news about a statement of objections. What's your comment? That was referred to in the evidence. I'll briefly give you that reference. In SB, Supplemental Bundle A, at tab 4, you have the witness statement of one of our primary witnesses, Mr. Xavier Chanet, and in it, on page 8 at paragraph 24, he deals with that very point and says that if anything had come of it, he would have expected to have been told, but he was not. So purely to correct the facts on that, that was not correct. Next, Ms. Ford said that Infineon's statement that the intensive internal investigations had revealed no suspicious facts did not reflect actual dishonesty on the part of her clients, because they genuinely thought that. And she took you to her pleading where they said that they maintained that in their submissions all the way up to the European Court. But the company was found guilty by the European Court of collusion, upholding the Commission's decision. And therefore, what Infineon did was, as I said in opening, effectively, in effect, in practice, to perpetuate the concealment of the wrongdoing, of the essential facts, because it places a block in the way of discovery of those essential facts of the course of action. And then Ms. Ford sought to limit it in time and said, well, that said nothing about what the attitude was later by the time of the statement of objections. If I may say that, that was not right, because what happened was, and we have the document in the bundle, that when the SO came out, Infineon reconfirms its position publicly at that later stage, and therefore it deepened that perpetuation. And you see that if you pick up the supplemental bundle. There are two documents, I'll only show you one. At SBE, at tab 10, this is the financial report for the quarter June 2014 by Infineon. If you go in it to the third page, you'll see 4 paragraphs down, paragraph beginning, in October 2008, the Commission initiated an investigation. And then 4 lines on April the 22nd, 2013, the company received the statement of objections. And look what they say, in which it was for the first time informed of the basis of the Commission's antitrust allegations. The company defends itself against all allegations of anti-competitive conduct. For this purpose, the company submitted its reply to the SO to the Commission and has subsequently reiterated its view on the case in writing and verbally. The company assumes the proceedings will be terminated by the end of this calendar year. However, it's not currently possible to reliably estimate the outcome of the proceedings. Now that...
I know it's late, I understand that, but just on this, it seems to me that it highlights what I find so difficult about this. If I ask what I hope is a simple question, when was the alleged cartel discovered? the answer is, well, certainly by the statement of objections time, it wasn't the decision that discovered the cartel. If you look at it from the public's point of view and ask that simple question, when was it discovered? It wasn't. It wasn't. This shows that the person, it's been discovered, they're denying it, but as sure as eggs is eggs, the cartel has been discovered by now.
My Lord,
And that's what the Act is about, isn't it? Limitation.
my Lord, you're right, that's what the Act's about. I differ on the question of whether it's been discovered, because,
Right, alleged cartel discovery.
Yes.
It's an allegation, it's not a cartel, it's
Well,
an alleged cartel.
and that makes all the difference.
That's what I said. For that reason, to the alleged
I
cartel.
see. Well, it's been, let me put it slightly differently then. It's been discovered that a cartel has been alleged. In other words, that there's a case to answer.
Yes.
And it is not, that the underlying infringement has not been discovered. And coming back to the policy issues that I was working through at the outset, and without putting a fine economic calculus on it, you ask yourself, as a matter of practicality, do you have a sufficient basis to justify embarking on the preliminaries to the issue of the writ? In this situation, when you properly understand what it is, you don't.
Well, maybe you do or don't, but it's still, I still don't understand how it can be said, which is your case, that it's the decision that is the discovery of the cartel, the alleged cartel. It just isn't the decision. It's no rational human being, I'll go that far, would describe the decision of a court analysing an allegation like that as the discovery of the thing being alleged.
My Lord, I agree with you that no rational person, or certainly after FII, would say that the decision of the court was to be taken as the moment of discovery. And this is not that. This is the infringement decision of the Commission, which is very different from the final authoritative decision of the court. This is actually the point in time when, for the first occasion, an authority, and there's nothing else to go on, says that it has found that certain events have taken place. And that is when you discover, as the reader, that this has happened. And that's our case.
I think we're going round in circles.
Yes, I'm sorry.
Well,
Kept quiet.
Well, my Lord,
I'll take the blame for that, Mr. Turner, don't worry.
deal with the remaining points very briefly. The European case is commenting on statement of objections. The NFV case that Ms. Ford went to refers to the fact that until the statement of objections, we haven't arrived at the state of a formal accusation. I say that is what it is, but it is not. The knowledge that there is a formal accusation in the European sense is not the same as recognising you have a worthwhile claim in damages. And as for the other case that she referred to, Treuhand, this says that a statement of objections is reflective of an informed view based on evidence of the Commission. There's no doubt about that. But then there was a reference to this point about whether the measures of inquiry themselves suggest guilt. That's including the request for further information. That is not right. They do not suggest guilt. And without going into it in detail, that is the point that we unpacked in the supplemental skeleton at paragraphs 42 to 49. Clark and Marlborough, as your Lordship well knows, Francis Bacon, there is no issue, there's never been an issue, that a claimant can rely on appropriate inferences to form a reasonable belief in the existence of the essential facts of the claim. But if Miss Ford is relying on Clark, or the other case, Gulati, for the proposition that an inference of the existence of facts can be based on material which is, provided it's more than fanciful, if that's the low bar, then that is wrong, and that is the point also dealt with in our supplemental skeleton. And finally, my Lord, the point that was canvassed with Lord Justice Green and Miss Ford at the end of her submissions about the treatment of the statement of objections as confidential and the significance afforded to it in practice in this sort of case. Ms. Ford's rightly referred us to Regulation 773 this afternoon. I'm grateful for that. But it's also relevant to note that at all times on the respondent side, they fiercely resisted disclosure of this SO precisely because they said it is of no consequence because it is an internal preparatory step which is irrelevant to any issue in this case, including this one. And if I may show you that, if you go to the supplemental bundle, I'll give you one
Every defendant says that in these proceedings.
well, let me show you the terms in which they said that, with which we agree as being accurate. SBF in the supplemental bundle, at tab 1, you have Renaissance's solicitors. You go in it to paragraph 4.8 on page 4. At the bottom of the page, they say the statement of objections, merely a preparatory document drafted solely to enable a party subject to the Commission's procedures effectively to exercise their right to a fair hearing. These considerations are compounded by the fact that, as recognised by Mr. Justice Popplewell in Morrison's and MasterCard, the relevance of the SO may be minimal or non-existent, given it's an interim step in the investigatory and decision-making process which may well have been overtaken by final decisions by the Commission. Now that's all correct. That is also how people in the business community view these things for all of the reasons that I've explained in this appeal. And so their perspective, which they offered for as the basis for refusing this document, was right. So, my Lord, final conclusion, this is a case where it would be, in my submission, unjust and contrary to the aims of Section 32 to rule that time starts to run against Gemalto from the date of a press release announcing the SO. On ground 1, the right time to take as marking recognition that you have a worthwhile claim, reasonable belief in the existence of the essential ingredients of the tort claim, is the time of the announcement of the decision. The conduct of Infineon in and after 2009, no suspicious facts revealed and so forth, is relevant to that conclusion. And on ground 2, it is, this is not a trivial point, it is in any event and must be clear that there was no proper basis for inferring that Gemalto purchased goods at an overcharge during the period that happened to be covered in an early factual information request. And Ms. Ford refers to paragraph 85 of the judgment below and says, well, it was addressed. No, it was not. That paragraph merely refers to the conclusion of the judge. There is no reasoning as to why it is a proper inference to be drawn. My Lord, I'm extremely grateful for your time. Subject to any questions, those are my submissions.
I think, just a mechanical matter, I think parties are going to provide us with chapter and verse on the status of an SO in EU and domestic law.
Yes, by the end of the week, please.
My Lord,
And agreed, please.
my learned friend opened one new authority,
AB and
AB.
Ministry of Defence, Mr.
and I
Chairman.
wanted to make one point about it,
Yes,
which is that Lord Phillips's judgment is a dissenting judgment.
right, okay. Well, that's very good, thank you. Excellent. Well, if Lord Justice Birss has no further questions for anybody, we will take time to consider our judgments. We want to thank everybody in court, counsel, juniors, solicitors, even clients. Interesting case, which raises important issues. When we hand down those judgments, we will do so under embargo. I think all of you now know that the terms of the embargo are very strict, and it would be useful if you would please tell my clerk, probably my clerk, who precisely is going to get a copy of the judgment and for what purpose, because we don't now allow it just to go into the ether. The time will be short. The purpose of your getting the judgment in draft is to point out typographical errors, not to re-argue the case. and also to enable you to agree an order and to discuss and agree the disposition of the case and the costs. If you're unable to do any of those things, then we will deal with those matters in writing by exchange of written submissions, again, unless we decide something really important demands an oral hearing. So I think that concludes everything, and with renewed thanks, that concludes the hearing.